Good morning, everyone. I would like to acknowledge the Elder Carol Martin for your kind prayer this morning and the unceded territory of the Squamish, Misquadis, and Tsleil-Waututh. My name is Nancy Martin. I'm very pleased to be with you today to talk to you about community development in the Indigenous community in the Greater Toronto Area, and specifically about the Misquadis case from a community perspective. I am grateful to be in the room with all of you, with all of your experience and your determination and all the accomplishments that you've made within your communities and how you have navigated the systems of government and to achieve the results on behalf of your communities. Miziwe Biik, Aboriginal Employment and Training. We advanced the Misquadis case with our community members, Roger Misquadis and Dorothy Phipps Walker, who's known as Winona. And as you know, it was a challenge to Section 15 of the Constitution about equality rights. This happened during a time that Miziwe Biik Aboriginal Employment and Training was delivering the Pathways to Success program. Some of you may remember. It was quite a forward-thinking program of the federal government that actually did give community control over the resources for employment and training initiatives to local communities. And it was a geographic funding allocation at the time. And Miziwe Biik was responsible for the Greater Toronto Area. Through Pathways, we were able to build up an infrastructure within our community, such as Leilani talked about, where Miziwe Biik was somewhat of a hub within the community, and many of the organizations were utilizing the employment and training funds for on-the-job training opportunities for our community members who come from right across the country. So for example, Aboriginal Legal Services was training court workers, Anishinaabe Health was training, and I shouldn't say was, but continues to train receptionists, community health workers. So we really leveraged the opportunity to control our own employment and training funds. There was a tremendous amount of community development at that time under Pathways, and an extensive community infrastructure was developed. Not only was that a strength for our Indigenous community in Toronto, but we developed a connectedness and a cohesiveness. And today, a lot of that is managed by Lindsay Kretschner from Task, who many of you know. She would probably attest to the fact it is difficult to manage us, but she does coordinate a lot of assets for our Indigenous community in Toronto. I did put the vision of Miziwe Biik up there, and as you'll see, despite the fact that it was developed early days in Pathways, it really speaks to self-determination. And we were well on our way to, self-determination, building that community infrastructure, economic benefits to enhance not only individuals, families, and making just an impact. And we also were building capital infrastructure. So it was a wonderful and great program until the federal government decided to redesign the employment and training program and introduce the regional bilateral agreements. And this is where I believe the distinction-based initiatives came forward, where the federal government was looking to negotiate employment and training agreements with the First Nations, Métis, and Inuit. That basically left Miziwe Biik and our urban delivery mechanism right out of the picture. And for that particular reason, we struggled. We struggled with government to try and make a rationale why we should not be put out of business. We are actually given notice to close our doors, which, being the Mohawk woman that I am, I did not heed their letter. But some of the actions that we did take prior to entering into Misquadis was we diversified our funding base. And so we were relevant on every level, other federal programs, provincial programs, and municipal programs. So we still had the economic base. But we were forced into taking a court challenge on this equality issue. And I know you're all very familiar with it, and I am so eternally grateful to our community members, Roger Misquadis and Dorothy Phipps Walker, who lent their names to this challenge. And it was actually initiated by some old school activists from the Niagara Peninsula area Aboriginal Management Board, which is similar to Miziwe Biik, only serving the Niagara area. And when I say old school activists, there really aren't many around today. And I think there's still a place for that role within our communities in order to make our voices heard. So we initiated the Misquadis case under Section 15, and we had a struggle because we saw the implications, the widespread implications of urban rights. And also, I know that you are involved in urban rights issues. And we saw that as an opportunity and a platform to advance other portfolios, whether they be justice or housing, and right across the board, Misquadis applies. We won the case, as you know, and then the Government of Canada appealed it. We won that again, and Government of Canada did not take it to the Supreme Court. I think just the lessons learned were, we always had a good relationship with our community. And I mean, this message has been echoed by Leilani and others who have spoken about community-based initiatives, is developing that relationship with your community agencies and your community members, and supporting what everybody's trying to do. One of the things that happened during Pathways, and which I will acknowledge NUICC and the coalitions, is during the Pathways process, we had regional meetings. They were called RAMBO, Regional Aboriginal Management Organizations met, and we had a national meetings also. And then when the RBA process came into place, that whole infrastructure was kind of disseminated. And even to this day, the Employment and Training National Network rarely meets. So that was an opportunity for government to kind of keep everybody in their little corners and not collectively get together and share best practices. And so I honor NUICC for that, bringing that national voice together. And it's really, really important. So having that vision of urban Indigenous people, we fortunately were able to create another distinction-based category in the eyes of the Government of Canada, which in fact is called the urban. They call it the urban and unaffiliated, but I find that offensive. So I call it the urban allocation, and we have an agreement through the Aboriginal Labour Force Development Circle, which is in Tyndonega. We refused to be pitted against any other groups, and we refused to be pitted against the First Nations. The Chiefs of Ontario always supported us. They made a resolution to support Miziwe Biik Aboriginal Employment and Training to deliver to their citizens who live off the reserve. And through those, again, through those partnerships, which also was mentioned by Leilani, through those partnerships, we have been able to really accelerate the development within our community, because we're working along somewhat seamlessly along with the First Nations in Ontario, and where most of our community members come from, and the urban population. So I think we pride ourselves in that positive energy within the First Nations. I think that's about all I have to say. I'm very happy to be here, as I said, and I think that there's a video that talks about the legal and the policy implications of Misquadis.
Thank you. Thank you so much.
Good morning, everybody. I'm sorry I couldn't be there, but unfortunately working in the university is like working in a petri dish, and clearly something has caught up with me. Sorry I didn't get a chance to meet everybody, but hopefully in the near future we'll get a chance to interact and say hi to one another. Anticipating that the schedule is set up the way that I was told, I'd like to thank the previous speaker for the historical context of an important legal decision. A decision that unfortunately has garnered limited attention since it was tabled by the Federal Court of Appeal in 2003. My goal today is to situate the Misquadis decision within Canada's social, legal, and policy landscape, a discussion that is underscored by the growing momentum that will compel Canada to decide on the status of urban Indigenous peoples. Do they have a right of self-determination or not? The answer to me is straightforward. Urban Indigenous peoples do have a right to self-determination. What that right will look like in practice is why events like today's gathering are vital. And things appear favorable on many fronts. When I review the policy, legal, and social history of Canada's understanding of who urban Indigenous peoples are, I see an institutional infrastructure has developed that offers several pathways for an Indigenous coalition to realize urban Indigenous self-determination. This aspirational talk seeks to identify several pathways to greater urban Indigenous self-government at the community level and self-determination at the provincial and federal government levels. To begin, what do I mean by institutional infrastructure? This aggregates the legal, policy, and social pathways that can empower the co-production of policy planning, a policy generation and implementation process where actors outside the government apparatus creates policy instead of only its implementation. Governments do not relinquish their public policy making responsibility when they engage in co-production. Instead, they proceed on the basis that there is value in co-production and shared responsibility for defining issues and priorities accurately and devoting public resources to programs stemming from the former that are likely to achieve good outcomes. With that brief introduction in place, I would like to acknowledge that my words are being heard in shared territory of Musqueam, Squamish, and Tsleil-Waututh people, also known as Vancouver. Returning to Misquadis, in Ardoch Algonquin First Nation versus Canada, Toronto resident Roger Misquadis sought access to the Aboriginal Human Resources Development Strategy. He was denied access to Human Resources Development Canada programming, which refused to consider establishing agreements with off-reserve Aboriginal communities and rural First Nations communities lacking reserves. The appellants alleged that the Aboriginal Human Resources Development Strategy discriminated between urban and off-reserve First Nations, and this was evidence of discrimination in violation of Section 15 of the Charter of Rights and Freedoms. The Federal Court of Appeal agreed that the proven discrimination violated Section 15 of the Charter. It further communicated the relationship between the rights of Indigenous peoples in urban areas and the role of urban Indigenous organizations vis-a-vis those rights. Though it produced some troubling reasoning, the court concluded that urban Indigenous communities are functioning Aboriginal communities as worthy of recognition as reserve-based communities that have rights to have the communities they have built accorded equal worth. The Federal Court of Appeal identified urban Indigenous communities as communities in law. After that, the Supreme Court of Canada's Daniels decision in 2015 broke down the jurisdictional boundaries that had previously inhibited urban Indigenous self-government aspirations and access to services. Specifically, Daniels clarified that all Indigenous peoples, including non-status Indians and Métis, are considered Indians under the Constitution's division of powers. As Indigenous peoples under federal jurisdiction, urban Indigenous peoples may express their rights to self-determination, allowing them to govern their affairs and make decisions for their communities. 2, urban Indigenous peoples may now engage with the federal government for policy changes and services previously denied based on jurisdictional issues. And 3, urban Indigenous governance structures may now access various avenues dedicated to meeting the needs and interests of urban Indigenous populations. Daniels does not identify urban Indigenous peoples as communities in law, a la Misquadis, but it does open several pathways to federal engagement. Perhaps more importantly, as Ian Peach has noted, both cases classify the denial of the right of urban Indigenous peoples to equal concern and respect with those off-reserve as unconstitutional. Federal legislation and policy have much to say in this regard. Dating to 1995, when the Inherent Rights Policy was tabled, urban Indigenous issues regularly arose. In just over 25 years, the right to Indigenous self-government was identified as inherent, with pathways available for negotiations with provinces and Indian groups residing off a land base to develop self-government arrangements. Though the cost would be onerous and currently there is no framework to guide formal talks, the Inherent Rights Policy provides potential pathways to forging forms of public government or the devolution of programs and services. Notably, in this context, despite the Inherent Right Policy's inherent limitations, its wording implies that the only way that a government can deny urban Indigenous communities the right to self-government is to deny that they're Indigenous. Misquadis, as noted, recognize urban Indigenous peoples as community in law analogous to First Nations. The United Nations Declaration on the Rights of Indigenous Peoples in 2007 outlined these rights of Indigenous peoples worldwide. It likewise provided a framework for promoting and protecting these rights, including the Indigenous right to self-determination. Notably, the UNDRIP made no urban-rural distinction. Canada signed on to these strictures in 2010. The Truth and Reconciliation's final report in 2015 further called upon federal, provincial, territory, and municipal governments to fully adopt and implement the United Nations Declaration on the Rights of Indigenous Peoples as their framework for reconciliation. Reflecting on Misquadis and Daniels, the courts identified the influence of historic policy and legislation on federal and provincial policy practices and how they in turn impinge on urban Indigenous peoples' rights to have equal concern and respect within those on reserve. Finally, the UNDRIP Act of 2021 has application in Canadian law and provides the framework for the federal government to ensure its laws are consistent with the Declaration. The UNDRIP Act also commits the Government of Canada to reject all forms of colonialism, and it is committed to advancing relations with Indigenous peoples, grounded in the principles of justice, democracy, equality, non-discrimination, good governance, and respect of human rights. As you can see, when read individually, Each case, law, policy, or declaration speaks to the importance of or recognizes outright urban Indigenous self-determination. When read together, there is much to herald, for you see the emergence of a much more extensive discussion occurring with an increasingly interconnected policy network regarding what urban Indigenous community means and its linkages to self-government policy. Upon closer scrutiny, an institutional infrastructure has emerged from Canada's long-term, albeit incremental, recognition of urban Indigenous communities as legitimate political communities. Systems innovation is nevertheless evident, albeit slowly developing, and this is why the urban Indigenous voice must be more conspicuous at policy co-production tables. Looking back, their absence in policy is a relatively recent phenomena. For example, the Native Council of Canada and later the Congress of Aboriginal Peoples were active and influential players. For example, the NCC signed the 1983 Constitutional Accord on Aboriginal Rights at the First Ministers' Conference on Aboriginal Constitutional Matters. The NCC expressed concerns about the Meech Lake Accord and its various governmental committees, and it received federal funding to participate in the 1992 Federal Provincial Conference of First Nations on the Constitution in Charlottetown. The institutional infrastructure highlights several essential developments in this regard. The UNDRIP Act, for example, requires the Government of Canada to work in consultation and cooperation with Indigenous peoples to develop an action plan to achieve the objectives of the UNDRIP. Federal and increasingly provincial and municipal officials promote the need for dialogue with Indigenous advisors and the significance of working more closely. Official policy documents regularly encourage these alliances. As an example, in the 2017 Urban Aboriginal Strategy Evaluation, which encouraged improving communications, widening the network of those able to access funding in support of urban Indigenous interests. More recently, as part of the UNDRIP Act action plan tabled in 2023, 2 points were presented that are pertinent to today's discussion. One, continue to support friendship centers and other urban Indigenous organizations and coalitions in their work to identify and address local needs and priorities of urban and off-reserve Indigenous peoples in a manner that is safe, secure, accessible, and culturally relevant. Secondly, the action plan suggested that it was time to address policy, program, and socioeconomic gaps and strengthen interdepartmental and intergovernmental relations in full partnership with Métis non-status, off-reserve, and urban Indigenous peoples, consistent with CAP and the Daniels decision. There's much to unpack here. For example, Canada's disapproval of its colonial history in the post-TRC era is common. The federal government encourages less siloed approaches to policymaking and provincial cooperation and policy development. It is also attempting to reconcile its ongoing reliance on institutions created in the 1870s and the 1880s, an era when assimilation was considered a progressive relationships. Despite several promising developments, we must never forget, urban Indigenous remains a blind spot in Canadian politics, policymaking, and jurisprudence. In 1966, the Hawthorne Report identified this tension. There has been an implicit assumption that the focus of Indian life was the reserve and that the reserve was a training school for civilization. As a consequence, off-reserve residence has tended to carry an assumption that the integration process was proceeding satisfactorily and that the task of the branch was ended. Hawthorne's concerns endure. For example, the Royal Commission on Aboriginal Peoples in 1996 emphasized land-based Indigenous nations' rights. More recently, the TRC collapsed urban Indigenous peoples into the term Indigenous. This blind spot has real-world implications. Take the policy vacuum the RCAP identified in 1996, described here as a space lacking program providers due to ongoing federal-provincial bickering regarding the precise responsibility for urban Indigenous peoples. In their attempts to declaim responsibility for urban Indigenous peoples, a gap has opened that leaves urban Indigenous residents with inadequate programming that was ad hoc to begin with, frequently produced in the absence of policy to fill program gaps quickly. The institutional infrastructure has the potential to mitigate these issues. For example, the Daniels decision should have resolved lingering jurisdictional questions for urban Indigenous peoples that date to the 1964 Federal Provincial Conference on Indian Affairs. At this conference, provincial premiers opposed the federal proposal to devolve Indigenous healthcare responsibility to the provinces based on their certainty in Ottawa's fiduciary duty for off-reserve Indians. Canada has nonetheless rejected the implementation of the Supreme Court of Canada's Daniels decision, which means the discriminatory treatment inherent within the Indigenous policy apparatus continues to harm urban Indigenous peoples. This blind spot, in turn, now places a tremendous onus on urban Indigenous leaders to amplify their voices. This is why I emphasize Misquadis, Daniels, and the UNDRIP Act. When read together and alongside existing policy initiatives defining the need for enhanced urban Indigenous political interventions, these cases and legislation can stimulate urban Indigenous political action, coordination, and authority when referred to in tandem. But this power must be harnessed first. This takes me back to 1968. Following the dissolution of the National Indian Council, the National Indian Brotherhood rose to fill the space and represent provincial and territorial organizations and status Indians. Still, it found securing Indigenous leaders' support difficult. That is until 1969, when Prime Minister Pierre Elliott Trudeau tabled his now infamous white paper seeking to quash the flawed but long-standing legal relationship enshrined in the treaties and in the Indian Act. Two critical outcomes resulted. One, in the face of stiff Indigenous resistance, the federal government retracted the white paper within 18 months. Two, Indigenous leaders quickly learned that collective action could influence policy, and their success affirmed that the federal government would have to consider the impact of a potentially hostile reaction before forging new policies. I am not promoting collective action as the solve or encouraging people to fashion a social movement, become activists, or engage in political activity. Or protest activity, sorry. As the previous speakers reminded us, these are essential political tools when appropriately mobilized. My point is this: Prime Minister Trudeau's poorly envisioned policy became the catalyst for Indigenous peoples, boasting an institutional infrastructure that enabled their quick and efficient response. Within months, a national Indigenous organization that was struggling to secure legitimacy quickly became the preeminent national Indigenous organization federal Canadian leaders later embraced, after which the White Paper's planned legislative termination of Indigenous peoples was rejected. This event forever altered the Canadian political landscape. Today, the infrastructure of urban Indigenous organizations, a nascent urban Indigenous coalition, is unmistakable. There is, however, no white paper per se catalyzing organized action. But when I read the various legal decisions, policy statements, and laws together, it's telling that their potential remains unrealized, which is not encouraging. Aspiring to co-production and negotiating urban Indigenous self-government into operations is one thing. There is, however, also a need to become self-coordinated and self-directed in the case of prolonged negotiations with the state. This is why Misquadis and Daniels, cases that are two sides of the same coin, and the UNDRIP Act, which demands additional deliberation according to the government's legislative directive, could catalyze those in their drive towards urban Indigenous self-government. It's not lost on me that in doing so, urban Indigenous self-determination is being offered as the means to secure urban Indigenous self-government according to Canadian laws and policies. How can these colonial pressures characterized by government oversight be managed? By forming a coalition that can self-determine absent government oversight. This brings me to the final element of my discussion: the central importance of Indigenous coalitions to the urban Indigenous self-determination project. Most people don't realize that the Indigenous coalitions, in the form of political organizations, date back to Canada's founding. In the 1870s, Canada's interest in Indigenous coalitions grew from their perceived potential to consolidate the diversity of Indigenous political voices into a few representative political organizations that could speak to and aid with federal policymaking. Admittedly, Canada's approach diluted the nation-to-nation arrangements articulated by treaty relationships that Indigenous leaders sought to retain. What it did do, however, was to establish a process that federal Indigenous policymakers continue to rely on in 2024, working with Indigenous political organizations to forge policy. Canada has embraced a historical practice that politicians, government officials, and political parties maintain, which has led to its increasing reliance on Indigenous coalitions for policy advice. However, based on federal policy, only a few coalitions are legitimate political representatives an outcome traceable to Canada's current distinctions-based approach to Indigenous policies, programs, policy development, consultation, and relationships. The distinctions-based approach, dating to at least 2015, sought to address previous shortcomings in pan-Aboriginal or one-size-fits-all approaches. Unfortunately, establishing the unique rights, interests, and circumstances of the First Nations, Métis, and Inuit has led to a hierarchy of inclusion that privileges three of the national Indigenous organizations, the AFN, the ITK, and the MNC. Excluding urban Indigenous peoples in this manner is troubling, considering that more than 60% of the national Indigenous population presenting unique, considering that urban Indigenous peoples are 60% of the national Indigenous population presenting unique policy and program needs. It suggests that costs keep Canada from coming to the table while pointing to an irreversible trend that federal and provincial officials must come to grips with. If that is Indigenous folks traveling through their territories and choosing to live in post-contact cities sited on traditional lands represents a trend. In recent years, urban Indigenous political interests have become constrained despite growing populations and appropriate demands for enhanced powers of self-government and self-determination. But as you can see, in this regard, there is interest and momentum building, a conclusion that's supported by four trends. The institutional conferral of urban Indigenous community legitimacy and the potential for urban Indigenous peoples to become self-determining under Canadian law. The institutional infrastructure is in place to aid with this exercise. Canadian government policy statements identifying a need for change, and urban Indigenous peoples are primed to establish enhanced self-government and self-determination institutions. Further, Canada seeks an Indigenous coalition to discuss how to best fill the existing service policy gaps and enhance urban Indigenous political representation. There is a self-professed need to safeguard these unique communities with unique needs. At a time when urban Indigenous leaders are discussing how to exercise their UNDRIP protected and inherent rights policy enshrined legal right to self-determination, my review of the relevant case law points to the court's support for their vision. Misquadis identifies urban Indigenous communities as communities in law, whereas Daniels simplifies the jurisdictional debates, encouraging urban Indigenous federal negotiations. As articulated in the UNDRIP Act, informed by the UNDRIP from 2007, the distinctions Canada identifies between urban Indigenous peoples and landed First Nations are false assumptions that originate in policy and are not found in the Constitution Act. It is an issue that must be reconciled, lest the post-2015 distinctions-based approach becomes further entrenched, thus continuing to alienate urban Indigenous peoples from the self-determining rights enumerated above, or more importantly, acting as the future policymakers and politicians' legal and political ground zero. Thank you very much. I hope that this has been somewhat enlightening. And if anybody has any questions, please email me. I look forward to meeting you guys in the future and through email, engaging in further discussions. Thank you very much.
To thank him and then realized he's not here. We can thank him anyway. There's a lot of great information.